Well, it's actually build the man a statue. That was a typo. And when I saw it, I emailed a YouTube clip from a Seinfeld episode that some of you might remember from the 90s when Kramer made reference to the statute of limitations. And Jerry and Elaine tried to tell him that it was actually the statute of limitations. He said, no, that's not right, it's the statute of limitations. And Jerry said, fine, it's the sculpture of limitations. That neatly leads into the beginning of my presentation. Some of you might be familiar with the popular animated sitcom The Simpsons. Few of you, I'll say with respect, will have quite the same level of learned and some might say scholarly familiarity with it that I have. But be that as it may, I've long maintained that there's a Simpsons reference for every occasion that life presents. And so, looking for inspiration as to the topic about which I might speak today, I turned, as I often do, to the wisdom of Homer. There's an episode from the show's 4th season entitled I Love Lisa, which centres upon the children of Miss Hoover's elementary school class and in part upon a school concert that the children present in honour of President's Day. One of the songs that the children perform is devoted to what they describe as the, quote, mediocre presidents. You'll be pleased to learn that I won't sing the lyrics, but they are as follows. We are the mediocre presidents. You won't find our faces on dollars or on cents. There's Taylor, there's Tyler, there's Fillmore and there's Hayes. There's William Henry Harrison. I died in 30 days. We are the adequate, forgettable, occasionally regrettable caretaker presidents of the USA. Now, I wouldn't presume for a moment to describe the subject of my address today as mediocre, quite the opposite, but the song got me thinking, who are the lesser-known architects of Australia's federation? When we think of our nation's foundation and of the debates that framed the birth of its constitution, most of our minds wander to names like Parkes, Barton, Deakin, Higgins, Isaacs, Reid, and of course, Sir Samuel Walker Griffith. But the story of Australia's constitution has a wider cast, and I thought today I'd speak about one of its extras, a fine Tasmanian by the name of Andrew Inglis Clark. And it's fitting that I might do so during a session entitled The Judiciary and Judicial Power, because as I hope will become apparent, the form and content of Chapter 3 of our Constitution owe as much to Inglis Clark as to anybody, and yet many in the room here today won't know much about the man. Indeed, I dare say that some won't ever before have heard his name. So let's change that. Clark was born in Hobart in 1848, just a few years before the end of Tasmania's convict era. He's said to have been delicate in his childhood. After attending Hobart High School, his future foretold briefly of life in his father's engineering business, but instead he was articled to a local solicitor and in 1877 was called to the Tasmanian bar. Clark developed a fascination with American law, formed in the shadows of arguably history's greatest constitutional struggle, the American Civil War. That devastating conflict captivated legal scholars throughout the English-speaking world who feared that equivalent colonial divisions might lend themselves to similar brutality. It was concerns of that nature that hastened the cause of Canadian federalism, and so too was it the case here. Clark, as a young man, was active within a movement in Hobart known as the American Club, which described itself as a collection of, quote, young ardent Republicans who met regularly to discuss what the newer British colonies of the South might learn from the Great Republic. Clark was indeed the most ardent of Republicans, and although always a believer that Australia should maintain its links to Great Britain and her Queen, supported with equal conviction what he referred to as the, quote, abolition of every institution that confers political power or personal privilege as an appendage of birth from a particular parentage. A year after being called to the Tasmanian bar, Clark was elected for the first of 2 stints in the Tasmanian House of Assembly. He lost his seat in 1882 whereupon he returned to the Tasmanian bar and he built a formidable broad practice. In the late 1880s, he returned to Parliament and served as Attorney-General in the government of Sir Philip Fish. There he was able to combine his talents, travelling to London in 1890 to argue on behalf of the state an appeal before the Privy Council. The case resolved, but Clark had occasion nonetheless to see the Privy Council in action. And as he'd later recall it, his experience of seeing most of the law lords asleep during a hearing reinforced in him a strong belief that appeals to that body from colonial Supreme Courts should cease, a position that he would come to reiterate with some force in the years that followed. Now, it was at around that time, of course, that the first green shoots of federation sprouted here in Australia in October of 1889. As you all know, Sir Henry Parkes delivered his famous Tenterfield oration, the first direct appeal for public support of what was to become the great constitutional project of the following decade. Clark was already at that stage a delegate to the Federal Council of Australasia, which was a body established by the Imperial Parliament in the mid-1880s, not an especially august institution. That council's now all but forgotten. It only ever met 8 times, always in Hobart for some reason, and never with any representation from New South Wales or New Zealand, and only occasional representation from South Australia. But it was nonetheless the first incarnation of intercolonial government, and Inglis Clark was part of it. After the Tenterfield oration, the push toward federation gained real momentum. In 1890, the Australasian Federation Conference, again as you all know, was held in Melbourne, the end result of which was agreement that a convention be held to draw a new constitution under which the colonies might unite. The first convention, again as you all know, was held in Sydney in 1891. What you may not know is that the task of identifying and debating content appropriate for a new constitution was split between 3 committees, each of which fed their deliberations into a much smaller drafting subcommittee, which comprised of its chair, Sir Samuel Griffith, then Premier of Queensland, former Attorney-General and future Premier of South Australia, Charles Kingston, and my man, Inglis Clark. Kingston and Clark had each circulated ahead of the convention his own draft document. Clark's was accompanied by a lengthy memorandum in which he was at pains to point out the inspiration that he'd drawn from the United States Constitution and the respects in which he'd eschewed elements of its Canadian counterpart, which other delegates, particularly Parkes, were known to favour. Opining upon the judiciary, Clark made plain his preference for the American system, writing, "I have followed the American model with an innovation which I think will prove acceptable to the people. The matters I have placed under the jurisdiction of the federal judiciary are the same as those placed by the Constitution of the United States under the jurisdiction of the Supreme Court of the American Union. And the innovation I have mentioned is the bestowal of the additional jurisdiction to hear appeals from all final judgments of the Supreme Courts of the several provinces. So, whereas appeals from US state courts to the US Supreme Court were limited to matters of federal law, the appellate jurisdiction of Clark's Supreme Court would, as now, know no such limit." Additionally, and perhaps harking back to his experience in London less than a year earlier, Clark continued, "This jurisdiction I propose to be final and to be substituted for the appeal which now lies from the judgment of the Supreme Courts to the Privy Council." When one thumbs through Clark's 1891 draft, and in particular Part 5, which he entitled Federal Judiciary, there are 2 respects that strike with immediate familiarity. The first is the similarity that it bears to Article 3 of the US Constitution. Both would vest judicial power in Supreme Courts established beyond the reach of legislative and executive impulse. Both would extend that power to matters arising under the Constitution and under Commonwealth laws, treaties and so on. Both would guarantee trial by jury, and both would guarantee the independence of federal judges, including by ensuring that their remuneration wouldn't ever be diminished. That one's very important, especially at the moment. The other source of familiarity is as between Clark's draft and our Constitution as it now reads, more than 130 years later. Clark's draft cemented the basic structure of our Constitution as it remains today, that celebrated merger of American separation of powers with a Westminster system of responsible parliamentary government. Sir Samuel Griffith, as chair of the drafting subcommittee at the 1891 Sydney Convention, was heavily influenced by Angus Clark's draft constitution. In March of 1891, he annotated a version of the Clark draft for discussion at the convention. All manner of edits were made, some of them substantive, most stylistic. Significantly, the provisions that Clark had inserted in the federal judicatory section were left as they were. Later, Griffith would come to prepare what he referred to as his first proof, a completed first draft constitution that would serve as a prototype for discussion amongst delegates at the first convention. That document was circulated to members of the First Convention's Constitutional Committee on Thursday the 26th of March 1891. The following day was Good Friday, and Griffith invited delegates to join him on his steam yacht, the Lucinda, which he had brought down from Brisbane for the Easter weekend. Clark, unfortunately, had taken ill with the flu the day before and was unable to join the others until Easter Sunday. In the intervening period, as the delegates sailed from Sydney Harbour to the Hawkesbury River, substantial progress was made on Griffith's first proof, not all of which was to meet with Clark's approval. Perhaps the most significant change was to what now appears as Section 71. The judicial power of the Commonwealth should be vested in a federal Supreme Court. As I mentioned earlier, Clark had conceived of the court much as Article 3 of the American Constitution had conceived of the US Supreme Court, namely as an institution that the founding document should establish and one that should be immune to the prevailing prejudices of Parliament. It was to be, in his words, a permanent part of the Constitution and not the creature of the legislature of the day. After their deliberations on Easter Saturday, the delegates on board the Lucinda had seen fit to tinker with that provision. Instead of enshrining the Supreme Court in the Constitution itself, the provision was amended so as to instead confer upon the Parliament a power to establish one. Little is known about how or why that change was made. Unlike the convention debates themselves, there are no records of the committee deliberations, and much less would one expect of the more informal deliberations that took place on board the Lucinda. There was, it's fair to say, more than token opposition at the time to the removal of causes from the colonial Supreme Courts, and in particular to the removal of rights of appeal to the Queen in Council. English merchants operating in the colonies saw the preservation of the latter as especially important, and it's perhaps conceivable that those interests were brought to bear upon the deliberations that took place aboard the Lucinda. Regardless, Clark was unimpressed. Reflecting some years later on what he described as the, quote, picnic on the pleasure yacht, he complained that the participants had, whilst enjoying themselves, tinkered with all of his judicatory clauses, and in doing so had, quote, messed it. It wasn't until the second convention in 1897 that the provision that now finds expression in Section 71 came to be restored. In a speech given in Adelaide in March of 1897, then Premier of New South Wales, Sir George Reid, implored the Convention to adopt a model in which judicial power vested in a court embedded in the Constitution itself. Recognising what Clark had recognised about the importance of its independence from the other organs of government, Reid explained, it is essential to the just exercise of federal powers that this Supreme Court be strong enough to do what is right, strong enough to act as the guardian of all the rights and liberties of the states and the people of Australia. Neither Clark nor Sir Samuel Griffith attended the Second Convention, which sat, as you all know, in 1897 in Adelaide and Sydney, and then in 1898 in Melbourne. Griffith by then was serving as Chief Justice of Queensland, Clark as Tasmanian Attorney-General. Both followed the Second Convention closely, and each was prevailed upon by his colonial government to give judgment on the draft bill as it stood after the Adelaide sitting. Opining of what was then a draft form of Chapter 3, Griffith was somewhat unenthused, observing in a paper that he delivered to the Queensland government that it had, quote, been to a great extent redrawn, and evidently by a different hand from that responsible for the rest of the draft constitution, the result being a somewhat abrupt change of style, which I venture to think a serious blemish. His Honour continued, the new style adopted is what may be called the catalogue style of drafting, which, although familiar to the draftsmen of 1891 and suitable to the case of an enumeration of a large number of subjects, as for instance in sections 52, was not considered by them to be compatible with the dignity of a great instrument of government. Clarke, it's perhaps fair to observe, was a little more upbeat, recording in an address given in July of 1897 before the Tasmanian House of Assembly his delight that the Adelaide draft substantially adopted what had appeared in the 1891 bill. Although he made a series of suggested amendments to it, the only one that concerned Chapter 3 was the same one that he'd made previously, decades ahead of his time, as it turns out, concerning the abolition of the right of appeal to the Privy Council. Now, I pause at this juncture to note a curious chronological feature of the constitutional conventions, namely the lengthy hiatus from 1891 to 1897. If one is looking for an interesting summation on that, one finds it in John Williams' documentary history of the Australian Constitution. It's only 3 pages long, but the explanation lends itself to an even briefer summation, namely economics and politics. In New South Wales, Sir Henry Parkes's sponsorship of the 1891 draft was met with opposition from within his own Free Trade Party, including from then backbencher and future Premier and Prime Minister George Reid, who shrewdly surmised that a new federation would come to be dominated by protectionists. Economic factors also bore upon its progress, to put it bluntly. Depression and drought meant that the colonies all had other things to worry about. Now, what does this have to do with Inglis Clarke? I'm glad you ask. Much as on the document itself, Clarke's fingerprints are also found upon the reinvigoration of the Australian constitutional project. In January of 1895, the Federal Council of Australasia, that historical footnote that I mentioned earlier, met for the 6th of its 8 times. Sensing his opportunity, Inglis Clarke set about convening a meeting of the colonial premiers who were then in Hobart. All of them attended, including Sir George Reid and Charles Kingston, respectively the premiers of New South Wales and South Australia. The meeting was informal, and there's no record of what it debated, but late in the evening upon which it transpired, Reid emerged from the Tasmanian Club in Macquarie Street and announced to the waiting press that the meeting had resolved that a further convention, comprising of delegates from each colony, would be held to draw a constitution that could be put for endorsement by popular vote. Much as Sir Samuel Griffith's, Clarke's involvement in the second convention was peripheral. After the Adelaide sitting, he proposed the insertion of a clause modelled on the US Constitution's 14th Amendment, the so-called Privileges and Immunities Amendment, a provision that I note was used with some success recently in America to defeat lockdowns during the COVID-19 pandemic. Clarke's proposal was defeated, and the convention ultimately settled upon the watered-down version that one now finds in section 117, a provision that in this country has borne no more helpfully upon recent examples of executive overreach than the absolute freedom that is the subject of the ambiguously unambiguous section 92. One could write a whole other paper about that, but perhaps Perth isn't the best place to deliver it. Whereas he failed to enshrine an Australian 14th Amendment, Clarke was more successful in enshrining the power of the judiciary to hold to account the other organs of government. At the Melbourne sitting of the Second Convention in 1898, Edmund Barton expressed some concern about the conferral upon the High Court of jurisdiction in matters in which a writ of mandamus or prohibition was to be sought against the Commonwealth. Understanding that the provision had its origins in Article 3 of the US Constitution, like so many others that Clarke had penned, Barton was concerned that the provision might be read as one of limitation, foreclosing upon other remedies that might also be prudent to feature as part of the Commonwealth's judicial power. Following debate in Melbourne in January of 1898, and on the urging of future High Court Justice Sir Isaac Isaacs, the clause was removed. It was, as we know, later reinstated. The reference to mandamus and prohibition was not inspired by Article 3 of the US Constitution, as Barton had theorised. In fact, its origin was in a clause contained within Clark's 1891 draft, which with minor amendment had made it into Griffith's first proof and ultimately into the bill upon which the first convention came to settle. It was Clark who had been astute to ensure that the legislature should not be competent to inoculate the executive against accountability for jurisdictional misadventure. Upon hearing of the amendment made in January of 1898, Clark sent a telegram to Barton. Its content's been lost to history, but it evidently referenced the decision of the US Supreme Court in Marbury and Madison. In a letter written to Clark in reply, Barton wrote, "I have to thank you further for your telegram as to the striking out of the power given to the High Court to deal with cases of mandamus and prohibition against officers of the Commonwealth. None of us here had read the case mentioned by you of Marbury and Madison, or if seen, it has been forgotten. It seems, however, to be a leading case. I've given notice to restore the words on the reconsideration of the clause." Clark's provision conferred upon the High Court original jurisdiction in matters in which a writ of mandamus or prohibition was to be sought against an officer of the Commonwealth. It was, or would appear to have been, taken from, or at any event was an analogue of, Section 13 of the US Judiciary Act of 1789, the very provision that Chief Justice Marshall struck down in Marbury. You may know in Marbury, the Supreme Court held that it only had appellate jurisdiction to grant mandamus and prohibition, and it struck down Congress's attempt to confer upon it the original jurisdiction that Mr. Marbury had sought to invoke. Clark sought to ensure that the High Court should have the original jurisdiction that the Supreme Court held in Marbury was beyond what the Congress validly could confer. Perhaps, as Sir Isaac Isaacs contended in opposition to its reinstatement, that power would exist whether stated or not. Certainly the Parliament would have retained the power to legislate so as to confer it, although knowing what we now know about privative clauses, it seems unlikely that it would ever do so. Regardless, Clark's provision made clear what might otherwise have been left for inference, namely that the judicial power of the Commonwealth should extend so as to confer upon the High Court the power to compel the other limbs of government to do or not do that which the Constitution or Acts of Parliament require or forbid, and thus were sown the seeds of judicial review of federal executive action in this country. It's been said that of the 96 provisions that Inglis Clark drew into his 1891 draft constitution, all but 8 found expression in one form or another in the 1891 bill that was endorsed by the first convention in Sydney, and there are only 10 that have no identifiable analogue in the version that was publicly endorsed in 1900. When Australia was federated, Inglis Clark had assumed his role as a Justice of the Tasmanian Supreme Court. His skill as both a lawyer and a draftsman were obvious, and there was serious talk about his potential appointment to the High Court. The founding government of Sir Edmund Barton was expected initially to appoint 5 justices to the new court, and Attorney General Alfred Deakin had already pegged Clark as an associate justice in a future Griffith court. But out of concern that the new court wouldn't have enough work to keep itself occupied, that number was reduced to 3 and Clark missed out. In 1906, when the initial fears about the court's workload were exposed as unfounded and the court was expanded in number, Clark was again on the shortlist, but again was passed over, that time for Isaacs and Higgins. A year later, Clark was dead. Frank Neasy, in 1991, a year after he retired from the Tasmanian Supreme Court, had occasion to wonder why the name Andrew Inglis Clark was so much less recognisable throughout the land that he had helped federate than those of his contemporaries, Griffith, Barton, Deakin, Isaacs, Higgins, Parkes, O'Connor. His Honour wrote, "The reason why Clark's name has faded in comparison with theirs is, I suggest, the plain one that he filled no public role in shaping the Constitution during the 1897-98 Convention, and no prominent part, either judicial or political, in the new federation. By contrast, all the others did." When I began my address, I described Clark as an extra in the production from which our federation emerged. That was grossly unfair, but it neatly demonstrates Clark's unfortunate recession from public consciousness. Had he played a similar role in the birth of the United States, history would remember him no less fondly than it remembers Hamilton, Adams, Madison and Marshall. Yet the recession here is significant. When one surveys a list of federal electoral divisions, no fewer than 15 are named in honour of our constitutional fathers. Clark is one of them, but the division that bears his name wasn't created a century or decades ago like the others. It was created in 2019, 130 years after Clark's seminal draft first made its mark. Former High Court Justice Michael Kirby, giving the inaugural and, from what I can tell, the second last University of Tasmania A.I. Clark lecture in 2014, noted of Clark that, quote, "No Tasmanian can justly claim on objective evidence a greater claim of influence in the shape of Australia's constitutional arrangements." His Honour is not the only Justice of the High Court to speak of Clark in that way. Sir William Dean famously described him as, quote, "the primary architect of our Constitution." And no less an icon than Sir Owen Dixon, with the other majority judges in the High Court's Boilermakers decision, referred to him as someone who, on matters of constitutional theory, was, quote, "entitled to speak with authority." I conclude with the words of Clark himself, written 120 years ago. They neatly sum up his conception of Chapter 3 in the exercise of judicial power. He wrote, "The supremacy of the judiciary, whether it exists under a federal or a unitary constitution, finds its ultimate logical foundation in the conception of the supremacy of law as distinguished from the possession and exercise of governmental power." Quite right. I thank the Society for this opportunity and to all of you this morning for the courtesy that you've shown in listening. Thank you very much.